get into some of the things that the tools that we use in order to be able to fight these, these credit bureaus and these debt collectors and everyone in between. So first and foremost, we use the FCRA, and which is the Fair Credit Reporting Act, against the credit bureaus and against, debt collectors and all these in the financial institutions. But as well as we actually use also the FDCPA, which is the Fair Debt Collections Practices Act. We use those against the junk debt buyers and the debt collection agencies as well. So these are the two of the main tools we utilize, as well as there's some other tools out there. But what these are, guys, these are actually congressional laws that were put in place for consumers to protect you against unethical acts from the credit bureaus, the credit reporting agencies, the debt collectors, the financial institutions, all of them. All of these entities have to abide by the Fair Debt Credit Reporting Act. Practices Act. I always get that messed up. And the Fair Credit Reporting Act. They always have to abide by these rules and these laws. And here's the thing, and I can't stress this enough. These laws are not new, but the thing that they bank on, just like the credit bureaus and we talked about, is the fact that most people will not know these laws even exist, let alone where to find the information, nor how to actually leverage that information in order to be able to fight them. So they play the law of averages. They know if 8 out of 10 people are walking around with issues on their credit reports, that means 8 out of 10 people are not going to know how to fight them. One of those other 2 that are still left may not even know or understand the fact of what these laws and everything are. And one of those other 10 people may be a person who doesn't have a credit report, doesn't have a credit score. They don't have enough information. And then that one person out of 10 may be the only one that has the knowledge they need in order to be able to fight them. And they're willing to play those bets because of the fact that usually they feel like they're the house and they always win. But in this situation, we're going to take the house because of the fact that the real house, which is the laws and Congress and the government, are on our side, the consumers, and they are not on the side of the credit reporting agencies or the debt collectors. Let me say that again. Congress and the U.S. government and all of the policies put in place, they are not on the side of the debt collectors and the credit bureaus. They are on the side of the consumers. And I will prove that to you here in a second. So let's see here. All right, let's get to it. All right, so I'm gonna stop sharing for 1 second and then we'll start sharing another screen. All right, so what we're gonna look at first, we are going to look first at the FCRA. And we're going to do is we're going to go through key parts of the FCRA that I specifically use in order to be able to get any and everything off of a consumer report for anyone. So, let me show you how I got here first. So let's just go to Google because I'll just come back to the other tab. So Google, and what you want to do is you want to type in 15 USC, that stands for United States Code 1681. That is going to be the section of the FCRA. Click enter. It's going to pull up Cornell Law and just go ahead and click it. And that'll bring you right here to the first page of the FCRA, which the first page of the FCRA is the first page of all of these laws, whether it be FCRA, whether it be the FDCPA. There's also something called the Truth in Lending Act. They're always going to have their findings or congressional findings. Basically, what that means is the congressional findings are always going to be references of why these laws and everything are put in place, why Congress is going to the point of writing these laws because they found a problem. All right, so now let's look at the first page of the FCRA. And the reason why I call it even the first page is because the first page is so powerful. But this is going to be something, guys, that I cannot stress enough. You're going to have to study, go back and re-listen to this recording and study, because once you know it, no one will be able to ever take this from you, and you will be able to not only affect your life in a positive way with this information, but all the people around you. So 15 USC 1681, Congressional Findings and Statement of Purpose. In the first sentence, Congress lets us know why they're doing what they're doing. It says accuracy and fairness of credit reporting. Now, here's the thing. For them to call out accuracy and fairness, just right off the rip, you know that Congress found that the vast majority of the practices by the credit bureaus were not accurate. They were not complete information. They were not reporting properly, and they also were not fair to the consumer. So that's the reason why, flat out, first line of the first sentence, they say the title of it is Accuracy and Fairness of Credit Reporting. And here is the first subsection of that. And this is really powerful. It says the banking system is dependent upon fair and accurate credit reporting. So let's take a look at that part. The banking system is dependent. That means the banking system cannot live without fair and accurate reporting. But we already looked at the numbers. We know that the credit reporting agencies are not being fair and they're not being accurate with the information they're reporting. Not if 80% of the people walking around have inaccuracies on their credit report. Okay, so it says inaccurate credit reports directly impair the efficiency of the banking system. So Congress is basically telling the consumer and the reporting agencies that inaccurate credit reporting literally is affecting the banking system, which means that is affecting the economy. Fair and accurate reporting means that we have a strong economy. Inaccurate and not fair reporting means that our economy is in disarray, and you can take that for what you want. Read definitely between the lines, and you will see what I mean. Inaccurate credit reporting is basically one of the reasons why our economy is in the state that it's currently in, because of the fact that these credit reporting agencies have not been reporting accurately. They've not been thinking about the fairness of the people that they're reporting on. They've just been lining their pockets with the funds for hundreds of years, and no one's ever chin checked them on it. Well, it's time for us to do that, because here's also something I want to call out. These laws that we're going to be talking about, these laws are not new. These laws are not something that just came out in the last year, the last 2 years, the last 10 years. Yes, they've had revisions, but these laws are not new whatsoever. It's just we were late to the game. So let's get in the game. All right. So it says, and unfair credit reporting methods undermine the public confidence, which is essential to the continued functioning of the banking system. So the Congress knows that if people don't have confidence in the credit bureaus, that means that they're not going to have any confidence whatsoever in the system itself, in the economy, in the banking system, in what keeps the lights on. Because of the fact that the credit reporting agencies are doing what they're doing, Congress is literally letting us know that if they keep going down the path that they are going and keep reporting information unfairly, keep not giving people equitable treatment and everything like that, that this entire economy can go down. Because think about it like this. Think about the economy as a corporation, right? Just like Walmart, just like Amazon, just like any other place that you know and love, right? If you and every other consumer stop spending money with them, what would happen? If you as the consumer and everyone, on the planet stop spending money with Amazon today, what would happen to Amazon? What would happen to Amazon as a company, their stock, everything? It would go down. It would plummet. There would be no need for Amazon. If nobody's spending money with Amazon, there's no need for Amazon to even be a thing, which means that if people stop spending money because there is no more public confidence and, everyone's credit is trash, that means our economy is going to tank. And I mean tank very, very, very bad. So that's something to keep in mind. This is the reason why I say that Congress and the government have your back in this case. They are your biggest weapons against these, the credit reporting agencies and the debt collectors and everything. They are your biggest weapon. And it's time for you to get in the game and use that biggest weapon against these people. All right, so let's go to line number 2. And I just want to call out that this section that we just read is 15 USC 1681 A1, okay? Now let's go to A2. An elaborate mechanism, that is the credit reporting agencies, has been developed for investigating and evaluating credit worthiness, standing, capacity, character, and general reputation of consumers. Now, the sad part is An elaborate mechanism sounds like something that is supposed to be foolproof. It's supposed to be, constantly working as it's intended. It's constantly supposed to be working in a positive way. But we know as well that this elaborate mechanism is actually not doing what it's supposed to be doing. It's not reporting fairly. It's not reporting accurately. It's not giving the right general reputation of the consumers. It's actually defaming the consumer and actually making it where to the consumer is not able to do the things that they need to do, which is go out and get more credit, which is have that good financial foundation, which is also have that good financial education as well, because informed information, informed consumers, they are going to be what carry the economy. They're going to be what make sure that everything keeps running, because the informed consumer, they're going to know how to leverage credit in a proper way and know that in leveraging credit in a positive way, they're going to be able to continue living and thriving and getting stronger and stronger and stronger. Think about it like this: a team's biggest weakness is their, that one link, that the weakest link. That team is only as strong as the weakest link. If the weakest link is the consumer, and that consumer has been plagued with misinformation, not being educated properly, unfair treatment, unethical treatment, not having the accurate credit reports, that makes that link is really weak. And if that link goes, the entire team goes. And in this case, it's not the entire team we're talking about, it's the economy, and it's our United States economy. So it is so important. And this is the reason why I say, and will keep saying, that you as the consumer have all of the power. You as the consumer have the ability to fight back against these, these unethical individuals. So let's keep going. Let's keep going through it. So that was A2. Let's go down to my favorite. And this is one that I want you guys to write down, because I want to tell you, this is one of the most powerful parts of the FCRA. And this really shows you your power. So this is going to be 15 USC 1681 A4. And what this one calls out, it says that there is a need to ensure that the consumer reporting agencies exercise their grave responsibilities when it comes to fairness, impartiality, and also respect to a consumer's right to privacy. Congress is telling you that your right to privacy is crucial to everything keep moving. So which basically means that you as the consumer have a right to dictate what is private and what is not. You as a consumer have a right to say, yay, that information is not information I asked or wanted you to publish. So you are not allowed to publish that. Take that off of my credit report, because you are violating my right to privacy. Because you are violating my right to privacy, now we have a bigger issue that we need to discuss, because of the fact you're violating my right to privacy. I never asked you to do that. I never gave you permissible purpose to do that. I never gave you authority to do that. So now you're in violation. Now, because you're in violation, get this off my credit report or face legal action. Okay. So this is one of the most powerful sections in the FCRA. Trust me, there are a whole lot of other really powerful ones, but this is one of the easiest ones to find and one of the bigger hitters in this. You can use your right to privacy when it comes to anything, because remember, it is your right to privacy. It is your right to privacy that is federally protected. Just like no one can come in your home and say, oh, this is a public place and I can go through all your stuff because this is all public supplies. No, that's not the case. This is my private information. This is my private domain. This is my private home. You are not allowed to come in here and tell me what to do, because that violates my right to privacy. All of this is mine. This is something that you own. You own your credit report. You own your credit file. So you have a right to dictate what is private to you and what is not. Okay. So once again, write this down: 15 USC 1681 A4. Now, another really, really powerful one, even on the first page, is 15 USC 1681 B. That is going to be this. It is the purpose of this subchapter to require that a consumer reporting agency adopt reasonable procedures for meeting the needs of commerce for the consumer credit. Consumer credit, they need to meet your needs, your consumer credit, personal insurance, and other information in a manner that is fair, that is equitable to the consumer. Only you can determine what is fair and what is equitable. With regards to confidentiality or right to privacy, like I said, very big. You want to use these. Confidentiality, accuracy, relevancy, and proper utilization of such information in accordance with the requirements of this subchapter, which means they have to meet your needs. They have to meet your needs to accuracy. If they're not accurate, they're not meeting your needs and they're in violation. If they're not respecting your right to privacy or confidentiality, guess what? They are not meeting your needs and they are also violating your rights. They are violating your federally protected consumer rights. And this is where you start holding them accountable. So that is 15 USC 1681A4 and 15 USC 1681B. Those are crucial, guys. And that's where I would say you need to really start your studying. Okay. All right. So let's go to the next page. Let's see here, which would be the definitions. Now, on top of the first page of the congressional findings, always study your definitions, because your definitions are going to tell you what applies to you. And your definitions are also going to give you basically that first wave of information that you can use against the credit reporting agencies, the financial institutions, and the credit bureaus. So let's go through a few key definitions really quickly. So a person. You guys may just think a person is just an individual, just an average everyday person like you or me. Well, it's not. And here's the reason why. How Congress determines a person is a person means any individual, partnership, corporation, trust, estate, corporate association, government subdivision, agency, or entity. That means our government is considered a person. That means the FBI, CIA, IRS, they are all considered a person on, I don't want to say people, but they are all considered a person on paper. They are considered a person on paper, right? So remember, a person can be an individual, a partnership, corporation, a trust, an estate, a cooperative, an association, government subdivision, agency, or other entity. But here's the caveat. You as yourself can be all of these things a person can be, but you only you, the consumer, can be considered an individual. An individual person is a consumer. That is a natural person born of two people. That is not a corporation. That is not a partnership. That is not a trust. That is not an estate. That is not an association, a government, a subdivision, or anything. A consumer is the one at the end of the day who has all of the power, because only a consumer can be considered an individual person. Because you are an individual person, you now have all of the authority over what all happens, because guess what? Without you, the consumer, nothing else moves. So that gives you leverage against these people as well, because you as the consumer have these federally protected consumer rights. But guess what? That partnership, that corporation, that trust, that estate, all of that stuff, those do not have the same rights as you. Now, a trust is a little bit different because it has its own set of things that it is used for. But everything else outside of that, there are really no exceptions to the rule, because of the fact a person, a consumer, is a living, breathing person. A person as a corporation, that's just a piece of paper. A person as a government or a government subdivision or an agency or anything, those are just pieces of paper. Those are not people. Only you as a consumer can be considered an individual person. But here's the beautiful part. You as the consumer get to choose when and where you are what. I want to say that again. You as the consumer get to choose when and where you are what. So you can pick when you want to be an individual. You can pick when you want to be that individual consumer, or you can pick when you want to be that partnership, that corporation, that trust, that estate, that association. You can even be a government if you wanted to, being honest, because once again, it's just a person. That's how Congress has it written out. That's what the law says. That's what we go by. All right. So consumer report. This is something else. And so once again, This is going to be 15 USC 1681A that we just read about person and individual person is going to be B and C. A consumer report is this. A consumer report means any. And once again, I can't stress enough, any means without exception, means any written, oral, or other communication on or in any information by a consumer reporting agency, which is consumer reporting agency can be anyone, bearing on a consumer's credit worthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living, which is used or expected to be used or collected in whole or in part for the purposes of serving as a factor in establishing a consumer's eligibility for credit, insurance, employment purposes, or other authorized uses under this subsection, which means that you, as a consumer, have anyone report any information on you, whether it be a post about your reputation, whether it be a credit report, whether it be anything. It doesn't have to be just a consumer report. It doesn't have to be just a credit report, guys. I want you to think broader. This is anything, any written document, any oral, presentation on you or anything is all considered a consumer report. Heck, even Facebook, anybody writes anything about you on Facebook, that is considered a consumer report because they are referencing your general reputation, your personal characteristics, your mode of living, all of these different things. These are all consumer reports. It is just not just a basic credit report. No, I want you guys to think everything is a consumer report. Anything that talks about you under any circumstances is a consumer report, which means anything that is talked about you, written about you, or anything can be disputed. So keep that in mind. Anything, there is no restriction. Any written, oral, or other communication about you is considered a consumer report. And that is really powerful and really crucial because that means that you dictate what is published about you, regardless of who it comes from, okay? So now we're gonna go down to exclusions. So this is 15 USC 1681A2 under exclusions. Now this is a really powerful one that we use constantly. Right here, let's see. Here we go. This is under exclusions, and I really want you to pay attention to this one, guys. This is under B. This is any authorization or approval of a specific extension of credit directly or indirectly by an issuer of a credit card or other similar device. Now, that basically means that any type of specific approval, like, for example, a car loan, mortgage loan, a credit card, a personal loan, those are specific extensions of credit. Those are specific authorizations of credit, specific approvals of credit, which means they are not supposed to be on your credit report unless you tell them you want them on your credit report. Once again, I'll say that again. They are not supposed to be on your credit report unless you tell them they are supposed to be on your credit report. Remember, you as the consumer, you control the narrative. You control what happens. So that is, once again, 15 USC 1681A 2B under exclusions. That shows you that any item that is on your credit report that is a specific approval or extension of credit is not supposed to be housed on your credit report, which means, guess what? Now you have an ability to get it off if it's on there. Okay. All right. Let's see here. Make sure we didn't miss anything. Now, medical debt. So one thing I do want to call out with medical debt is, guys, medical debt is a sensitive topic, and it's sensitive for a reason, because why? It involves your right to privacy. I'm not talking about HIPAA or anything like that. I'm talking about your right to privacy and confidentiality. If you have on your credit report something that says, for example, anesthesiologist or dental or what have you, or, cosmetic surgery or anything, that is somebody publishing the fact that you had a sensitive procedure done. That is against your right to confidentiality, and that is against your right to privacy as well, which means, guess what? If it's not supposed to be there, you have the right to be able to get it off. Sorry about that, guys. Some dogs fighting. One moment here. Okay, we're good. All right. So once again, you have a right as a federally protected consumer to make sure that your information, regardless of what it is not published on your credit report unless you allow it to be. And that goes for any type of account on your credit report. Right now, we're just talking about medical debt, but remember, this is any account, regardless of what it is. If the information is published without your consent, it is against your privacy and confidentiality rights. Also, too, remember, if it is inaccurate, if it is unverifiable, if it is incomplete, corrupted, that means it's not 100% accurate. And what do we already talk about? If it's not 100% accurate, it means it should not be there. Okay. All right, let's go on to the next one. Really, guys, when you guys start studying, please definitely really dig into this definition section. In both cases, whether it be the FCRA or the FDCPA, really dig into those definition sections, because they will spin you off on a spider web of so much information that you will be able to use. Or you can always contact me and I'll be able to help you. All right, let's go back to it. Okay. So one other thing that I want to call out in here, but like I said, these are all subsections of laws that you can use against the credit reporting agencies. Let's go to E 1681E. So that's 15 USC 1681E, and we're going to go down now to B. This also, once again, talks about accuracy of report, which says whenever a consumer reporting agency prepares a consumer report, it shall, that means there is no wavering, they have to do this. It shall follow reasonable procedures to assure maximum possible accuracy. What is maximum possible accuracy? Maximum possible accuracy is 100%. Congress is calling out that the credit reporting agency have to have procedures to assure maximum possible accuracy. The most possible accuracy that you can possibly get, and the maximum is 100%. So they're telling you that the credit reporting agencies have to report 100% maximum accurate information. And if it's not information that is accurate, if it's not 100% accurate, guess what? That means it has to go. All right, now let's go down here to where it talks about what to do when they do run into the, oh, no, I'm sorry. This is the one. Let's go over here. So hang on. So let's talk about this once again. Maximum possible accuracy. Okay. Maximum accuracy. Now let's talk about what they're supposed to do when they see that it's not possibly accurate. So we're going to go to 15 USC 1681I, procedure in case of disputed accuracy. Guys, this one is crucial. So let's go down here. All right, treatment of inaccurate or unverifiable information. They already tell you what they're supposed to do when the information is inaccurate or unverifiable, which means that they know that without a shadow, and the credit reporting agencies and financial institutions, all of that know this stuff, but they are going to also play dumb because of the fact, remember, it's not their job to tell you your rights. It's your job to know your rights and invoke your rights. So treatment of inaccurate or unverifiable information, once again, that's 15 USC 1681I. It says promptly delete. The credit reporting agencies shall promptly delete the item of information from the file of the consumer. Promptly delete, which means that they have to delete it if it's unverifiable, if it's incorrupted, if it's inaccurate, if it's not reporting 100% maximum accurate information, that means it gotta go, okay? And once again, that is 15 USC 1681I, 5I. So once again, that's 15 USC 1681I, 5A1, or I. Right here. All right. Please go back and study this one. All right. So now what I want to talk about is holding them accountable. Remember, all of these are violations of the law, which, just like any other violation of the law, has a monetary value attached to it. And I want to show you guys what that monetary value is. So let's see here. Here we go right here. Civil liability for willful non-compliance. Willful non-compliance, which means that they know that they are not being compliant and they know what they are doing. So this is why we're looking at the willful non-compliance right here, subsection A and B, right off top. It says any actual damages sustained. So if you actually get denied for something, if you actually get denied for those trucking loans or anything else, and they're reporting inaccurate information, anything that you would have made is the actual damages that you sustained. Anything that you are actually going to make from that deal is the actual damages you sustain. And that means the credit bureaus, the credit reporting agencies, and all of the above are on the hook for that amount of money to you. They're supposed to pay you. Or what will happen is or for just every violation, say you did not actually miss out on that trucking or anything like that, but you know that they violated you. So it's either the actual damages or it's going to be a payment to you for each violation of at least $100, but no more than $1,000. So every violation holds a weight of $1,000 that they are to pay you every time that they violate. Think about that. If you have 100 violations, and remember, there's no statute of limitations on fraud or this information. If you have 100 violations that you can show proof of, which all you got to do is pull your credit report and look at it and pull out all the violations, it's 100 grand. What could you do with 100 grand of free money? Just think about it this way. For hundreds of years, they have taken free money from you, your family, and everybody else in between, your community and our communities. They have taken free money from us constantly from the jump. It is now time for us to do the same. Like I said, we're late to the party, but guess what? We are here now. Now we know this information, and now it's go time. Okay. So the actual damages or any amount between $100 or $1,000, but guess who gets to dictate what it is, whether it be 100 or 1,000? You do. You as the consumer do. There's a lot of people in this industry that make a whole lot of money just doing this business model alone, going after these individuals for these violations. This is life changing, guys. This is life changing information. And like I said, it even calls out it even calls out in subsection B. In the case of liability of a natural person, obtaining a credit report under false pretenses or knowingly without permissible purpose, which means permissible purpose means that you didn't give them permission, the actual damages sustained by the consumer as a result of the failure or $1,000, whichever is greater. So in this subsection, they're telling you it's either going to be your actual damages or $1,000. Here, they're actually telling you if it's a person. Remember what we talked about a person. You can go after them for the actual damages or $1,000, which is ever greater. So this is going to be for the CRAs. This is going to be for everybody else. Remember, they can be either or, and you determine what you're going to go after them for. It's either going to be, the actual damages, or it's going to be $1,000, whether you're going after the CRAs, whether you're going after the financial institutions, what have you. It's either going to be either or. So you got it. It's your choice what you want to do. Okay. All right. So let's see here. Let's make sure we didn't miss any other really pertinent ones. Like I said, guys, this is going to be something you're going to have to go back and study, because we could spend hours here. And I think we've already have, but remember, guys, this is information that's always going to be available to you. All right. So now that we've talked about the FCRA, let's move over and transition to the FDCPA real quick so we can talk about them as well, too. And we're talking about now debt collectors. We're talking about now debt collectors. So this is just like you found the FCRA. You go back to Google, type in 15 USC 1692. That's going to be the FDCPA. Okay. And just like before, we're going to start with the congressional findings. So right off the bat, that Congress is going to tell us that abusive practices. So right off the bat, they already know that the debt collectors have been abusing the consumer I don't even know how long. Since this all became a thing, they realized that debt collectors have been abusing the consumer. So let's look at it. So it says subsection A, which is 15 USC 1692A, there is an abundant evidence of the use of abusive, deceptive, and unfair debt collection practices by many debt collectors. Abusive debt collection practices contribute to a number of personal bankruptcies, to marital instabilities, loss of job, and invasion of individual privacy. Once again, that word privacy comes back up. The reason why it keeps coming back up is Congress wants you to know that above all else, your right to privacy cannot be infringed upon by anybody. It doesn't matter who it is, whether it be a debt collector, the financial institutions, the car agencies, the credit reporting agencies. It does not matter. They cannot infringe upon your right to privacy. It is crucial that you realize that. But look at it. Look at also this is some things that I want to call out. These debt collectors, Congress knows that this is the reason why people have to file bankruptcies is because of these debt collectors. The reason why the divorce rate in our country is so high is usually due to financial issues. That's why they call out marital instability, to loss of job. The debt collectors keep calling your job over and over and over and over and over again to the point where your boss is like, look, man, I'm tired of this. You got to go. Loss of job or invasion of individual privacy. That means the debt collector is saying that they're going to blast your information everywhere and basically torment you and ridicule you for forever until you decide to actually break and pay them. These are the unfair and abusive practices that these debt collectors have used for decades against the consumer, against us, and it's time to change it. So let's get into it. All right, inaccuracies of the laws. So they know, Congress knows that the laws that were in place before the FDCPA were trashed. They did not do anything. It even calls out existing laws and procedures for readdressing these injuries. They don't even call them issues or violations. They say these are injuries because they are literally hurting you, are inaccurate, are inadequate to protect the consumer. So they're telling you flat off the bat that these injuries that these debt collectors are causing, the high bankruptcy rate, the high divorce rate, the loss of job, the stress, the anguish, the defamation of character, all of this. Congress is telling you that these laws that were put in place prior to the FDCPA were inaccurate in addressing all of these things that the debt collectors use to hurt you. So they're telling you, you've been hurt. You need to now remedy this situation, remedy these injuries by using the FDCPA against them. This is the tool, the bat that you are going to use to go head to head with the debt collectors, all of them, regardless of who it is. All right. So let's look at it here. All right. So it says the purpose of this subsection is to eliminate abusive debt collection practices by debt collectors to ensure that those debt collectors who refrain from using abusive debt collection practices are not competitively at a disadvantage, and to promote consistent state of action to protect the consumer against debt collection abuse. The end of the day, Congress has your back and they are trying to protect you against these abusive tactics by these debt collectors and these unscrupulous, unethical individuals, these junk debt buyers, and all of these individuals in between. So the debt collection agencies for years, we all know, we've all heard those horror stories where debt collectors will call your job. Debt collectors will, harass you at home. They will harass you at all times of the night. They will call you and just start screaming on the phone, cussing you out, all sorts of other things that they have used to try to manipulate you into paying them. And here's the thing, even if you pay them, they still may not go away because we've heard of those issues as well too. All right, so let's get into this. Definitions again. Really dig into these definitions, guys, because it is going to call out exactly who the bureaus are. The bureaus are actually not the credit bureaus. It's actually the CFPB, the Bureau of Consumer Financial Protection. That is, the CFPB is actually the bureau that they're talking about. So remember, guys, the reason why we want to go through the definitions is because we want to unlearn and relearn. We want to unlearn all of the terms and everything we think we know and actually go off what Congress is saying, because what Congress is saying, that is going to be what's going to protect you. That's going to be where your leverage is. That's going to be the teeth you use to fight against these individuals, okay? All right, so let's see here. So let's go to one of the main. So I want to answer a main question that I get a lot, and I want to answer it by looking directly at what Congress says. So one of the main questions that I get a lot all the time is, hey, Credit Vegan, what happens if a debt collector, sues me or sends me information from a law office? What do I do in that case? And I tell them, hey, look, what you do in that case is you collect a check. And they say, what do you mean? I'm like, because they just violated you. They just severely violated you because guess what? One thing that I do want to call out is if you do receive any information from a law office or anything of the sort, or an attorney saying that, hey, this letter is in reference to collection of a debt, or this is in reference to any information used will be used in collection of a debt, you have just been violated. And I'll show you why here. But let's get into this section first, and then we'll go down to it. It says, and this is once again 15 USC 1692E. Once again, that's 15 USC 1692E, okay? It says the debt collectors may not use false, deceptive, or misleading representation or means in connection with the collection of any debt without limiting the general application of the foregoing. The following conduct is a violation of this subsection. So remember what I said, guys. A attorney or a law office cannot contact you and collect any debt. Because guess what? If they do that, that makes them a debt collector. And what an attorney cannot be, and his attorney cannot be a debt collector. And here's the thing. I'm not speaking from my words. I'm speaking from what Congress says. Actually, specifically, right here. Right here. This is number 3. So that is 15 USC 1692E3. The false representation or implication that any individual is an attorney, or that any communication is from an attorney or their office, which means that any letter that you get that says this is in reference to collection of a debt from Joe Blow Law Office or Joe Blow attorney, guess what? They just violated your rights. And just like the FCRA, the FDCPA does carry a financial weight for any and all violations. And guess what? It's also $1,000 as well. So remember, if you get any letter from any law office or anything like that saying that this is an attempt to collect the debt, guess what? They just violated you, and now it's time for you to get the bag. Because of the fact that they cannot do that, an attorney cannot represent or be a debt collector. So as soon as they do that, they have violated your rights. But just like we talked about before, they know that the vast majority of the population does not know this information. So the vast majority of people are going to see, oh my God, I got a letter from this law office, and they're like, oh my God, I got to pay it, I got to pay it, I got to pay it. And what do? They pay it. And guess what? The debt still does not go away. That still, and another, debt collection agency may come back later on and still try to get you back for the same debt that you paid the law office for. And now you're like, what's going on? But if we know the ways to fight these individuals, we know what we need to do in order to be able to get it removed off of the consumer report. Because if they violate you, guess what? You can now go after them. And remember, each violation, that means each letter, each call, each time that they contact you, is a violation. And within that one violation, I guarantee you will have a whole lot of other violations each time that they communicate with you. Because why? Because no one has chin checked them on any of this information before. So that means that they have gotten so comfortable with violating your rights that they don't even care, because they know that the vast majority of people are not going to know the information. So they're not going to say anything. They're just going to do what they're told to do. And we're not those people. We're not going to just blindly follow just because somebody says, go this way. We're going to know our rights, and we're going to invoke our rights to be able to make sure that that it is always in our best interest what happens. Remember, you have 100% control over your credit report and over anything that is published on your credit report. And you as a consumer, you have all the power. Once again, I cannot say that enough, and I cannot stress that enough. You once again have all the power. I want to talk about another thing as well too that I've gotten from some clients that they've asked, that they've gotten a letter from a debt collector saying that if they don't pay this, they're going to go to jail. Once again, that is illegal, and it is against the FDCPA, because it calls it out right here. It says the representation or implication of that a non-payment of any debt will result in arrest or imprisonment of any person, or the seizure or garnishment attachment, or sale of any property or wages of any person, unless such action is lawful, which it's not, because who has the power here? And the debt collector or creditor intends to take such action, which guess what? A debt collector cannot cannot be represented by an attorney. Why? Because we just talked about why. So that means they cannot show up to court. They cannot do any of that information. And if they do try to do a judgment against you, reply to the judgment and call out to the judicial body and say that I do not recognize this debt, and this individual is breaking my federally protected consumer rights laws because they are representing themselves as an attorney and they are a debt collector. Boom. There you go. Now, once again, remember, go back and re-listen to this, and go back and also study this information, because knowledge is power. Knowledge is the great equalizer, because the difference between, the Larry who has, perfect credit, and the one who had, who dealt with, all the debt collectors and the freaking payday loan companies and all these individuals. The only difference between those two people, this me and that me, is the information. That's the only difference. Nothing else changed. It was the information that I had access to that gave me that perfect credit. It was the information that I have access to that gave me everything that I wanted and relieved so much stress in my life. So this is the reason why I say, guys, knowledge is power. Go back and re-listen to this and study, and then go after what you want. That is perfect credit. That way you can do whatever you want in life, okay? All right, so let's see here. All right, so let's keep going. All right, so let's say harassment and abuse, right? So this is 15 USC 1692D, harassment and abuse. And one thing I do want to call out, guys, is remember, these are not singular laws to be used by themselves. These laws can be compounded with each other, and each one of them is a violation. So the more laws you have on your side, and the more laws you know, and the more laws that you know that they've violated, guess what? Now you have the ability to really go after them for what you want and really make them pay for treating you unfairly and mistreating you. So harassment and abuse. A debt collector may not engage in any conduct, the nature consequence of which is to harass or oppress or abuse any person in connection with the collection of a debt, without limiting to the general application of the foregoing. The following conduct is a violation of this subsection, which means they cannot harass, oppress, or abuse you under any circumstances. And guess what? Who would dictate if they're harassing? Who dictates if they oppress you? Who dictates if they abuse you? You do. Once again, you as the consumer have all the power. Take your power back and go get them. Okay. And once again, look, it even calls it out right here. When they talk about arresting you or anything like that, they cannot do that. The use or threat of violence or other criminal means to harm physical person, reputation, or personal property. If they try to say that they're going to arrest you, or try to say that they're going to harm you at work, or harm your credit report or anything like that, guess what? That is harassment, abuse, oppression, and they cannot do that. It specifically calls out they cannot do that. So anything that you feel is harassment, anything that you feel is oppression, anything that you feel is abuse, those are your violations. They cannot cuss you out or use any profane language. I don't know about you, but anything a debt collector says to me is going to be profane. It's going to be obscene and profane. You dictate that. Once again, you have all the power. Because you have all the power, use your power, okay? And this is going to be 15 USC 1692D 1 and 2. I want you guys to go back and read these. Actually read all of these, okay? All right, so let's see here. Just going to do like one or two more. Actually, one more, and then we're going to wrap it up. All right, so 15 USC 1692G. You guys all know and love this one, because if you've been in the social media space where you talked about, credit repair and anything like that, you've heard 609 letters, 609 letters, 609 letters. Well, what people usually don't tell you is where the 609 letter comes from. This is actually where it comes from. So 15 USC 1692G is going to be your 609 section. That's where the term 609 comes from. It's the validation of debts, which basically overall means that you, as the consumer, it is not your responsibility to prove the debt is yours. It is only the responsibility of the party that is saying the debt is yours to prove that that debt is yours. Now, remember, you are the one who dictates and has all of the power. So if you are telling them, hey, look, this is not my debt, if they are saying that it is, ask for proof. This is where we ask for proof. This is where the 609 letters and everything come in. Ask for proof of the debt. Make sure that they have legal right to the debt. Make sure that they can provide you a promissory note. Make sure that they can provide you the original contract with your original signature, because guess what? More than likely they won't be able to, and more than likely, if they are not able to, it's not even more than likely, it's if they are not able to, we already know what's supposed to happen with inaccurate and unvalidated information. If it's inaccurate and they're not able to validate it, guess what? We already talked about that in the FCRA. If it's not validated, it has to be removed because it's inaccurate, it's corrupted, it's incomplete. Because of the fact it's inaccurate, corrupted, or incomplete, or unvalidated, it got to go. And now you have the subsections to not only fight the CRAs, but now you have the subsections to fight the CRAs along with the debt collection agencies. Because guess what? You can interchange these and use them in tandem with each other. So you can use laws from the FCRA and the FDCPA as well and get what you want, and make sure that they understand that you're just not the average everyday person. You know what you're talking about, and you will go after them if they continue to violate you. And guess what? Usually in this case, they're not going to want to buck. They're not going to want to fight, because they know that in this situation, they're going to lose because the law is on your side as the consumer. Okay. So this entire section, guys, read it, all of it. This is going to be what really helps you understand where 609 comes from and how to really use it to your advantage. And because you'll see some people will say that they don't get traction with 609. Well, the reason why is because they've never studied the actual base information where the 609 comes from. Once you know where the 609 comes from and the information that is in this section, you are going to be so powerful when it comes to addressing any situation that comes up revolving a debt collector or the credit bureaus. Okay. All right. So let's see here. So, that's pretty much the conclusion of us going through the laws, because I want you guys to really go back and study all of these. Like I said, all of these are a wealth of knowledge on things that you can do against the debt collection agencies as well as the credit bureaus. So one thing I do want to call out, when I say that you guys have all of the power, I mean it. You guys have all the power, and I'll give you a case in point. Remember that right to privacy. How many times privacy came up in our presentation? The reason why it came up so many times is because it is super important, because the Congress and the courts, they know that you have a right to privacy, which means, and I'm going to give you a gem for anyone who has, let's just say, public record. Remember, those public records came from a court. The courts and the government and everything do not deal with the credit reporting agencies. They do not deal with any CRA whatsoever. I don't care if it's LexisNexis or Equifax, TransUnion, ARS, Innovis, Check Systems, whatever. The courts themselves do not, under any circumstances, validate or become the source of information for the credit reporting agency. So I want to tell you guys something. When you go back and look at your credit report, if you have any public record on there, you will see where it says the source of information or the furnisher of the information is going to be the courts. Guess what? If you contact the courts and ask them, hey, I want to dispute this with you because this should have never been on my credit report, the courts are going to tell you they don't know what you're talking about because they've never talked to any credit reporting agency. Once again, think about what I just said, guys. The courts are going to tell you there's nothing to dispute with them because they have never talked to or validated any credit reporting information from any credit reporting agencies. Why? Because that would be a violation of your right to privacy and confidentiality, and that will make the courts then liable, and the courts are not going to be liable because the courts know the laws. So if the credit reporting agencies are saying or the financial institutions, debt collectors, whoever, are saying the source of information is the courts, you know that they have just made and generated a deceptive document, which guess what is another violation. So you guys with public records or anything like that, challenge the public record and ask them where the source of information came from and cite the laws that we've talked about, and to go back and read some more, because I want to tell you guys there's even more laws in there for this same thing, and you can use them all against them, and you go after them for violating your federally protected consumer rights. So once again, guys, remember, no courts, I don't care what court it is going to be the source of information or the furnisher of any information to the credit bureau. They are not going to, under any circumstances, work with the credit bureaus whatsoever. And actually, they will even tell you that there's no way to dispute with them because they never gave your information to the credit reporting agencies in the first place. So now at that point, now the credit reporting agencies have to prove where they got the information. And as soon as they try to say it was the courts, guess what? Now you got them. All right, guys. So I really hope you guys have, really, let me stop sharing. I really hope you guys